ladies and gentlemen. As I said, my name is Oręziak, and I hold a PhD in law, and I'm an assistant professor, as I underlined this at the beginning of the panel, at the Faculty of Law and Administration at Kardynał Stefan Wyszyński University in Warsaw. I'm also a member of the Polish-Hungarian Professors Network. For the reason I'm here to present my speech for the years 2025-2026. And within this network, I take part in a research group entitled Accountability of Constitutional State Organs in the Context of Rule of Law Crisis, led by Professor Marcin Wielec. Thank you very much for your leadership. Our research focuses on the responsibility of constitutional state organs in situations of rule of law crisis. In my case, I look at this problem mainly from the perspective of international and European law. And it's a great honor for me to take part in this conference and to share with you some of my reflections within this research framework. So, ladies and gentlemen, at the beginning, I would like to thank the organizers for the invitation and for the opportunity to take part in this conference. The title of my presentation, as you can see at the slide, is the Accountability of the State and its Organ for a Constitutional Coup, the Data under International and European Law. The starting point of my presentation is a simple observation. In modern legal systems, we increasingly see actions taken by the authorities which, at least formally, although sometimes even this is questioned, are based on existing law and carried out within legal procedures. At the same time, these actions may raise serious doubts as to their compatibility with the principle of the rule of law. This is especially the case when legal instruments and power of the state are used in a way that leads to significant changes in the constitutional order. In this context, an important question arises about the role of international and European law. In particular, we may ask whether these mechanisms are used only to protect individual rights or whether they may also be used to justify and curtail actions of public authorities. This leads to a broader question: whatever international law is truly natural, or whatever it is influenced by certain interpretative tendencies that affect its impact on domestic constitutional systems. Finally, this brings us to the key question of my presentation. It is possible to assign responsibility not only to the state, but also to individual public officials, and how far international and European law should go in this area. In other words, do international and European law provide real tools to ensure accountability in such situations, or does this responsibility remain mainly within domestic law? This is the question, of course. Ladies and gentlemen, the starting point of my presentation is a simple observation about the modern legal systems, as I said. More and more often we see actions taken by public authorities which are presented and based on existing law and carried out with legal procedures. And at the same time, even this formal legality is sometimes questioned in practice. More importantly, regardless of this, such actions may have serious consequences for the rule of law and the constitutional order. In practice, they may affect the balance of powers, the independence of institutions, and real protection of individual rights. As a result, we can see a clear tension between formal legality and the actual constitutional effects of the actions. And it is exactly these tensions that leads to the key question of my presentation: whatever international and European law are able to respond adequately to such situations. Ladies and gentlemen, at this point, I would like to introduce a concept which is essential to my presentation, the concept of the constitutional coup d'etat. Unlike a classical coup d'etat, this type of situation does not require the use of force in the traditional sense, such as physical violence or more military action. It may take the form of actions based on existing law and carried out through state institutions. What is important here is not the form of the actions, but their real effect. If they lead to a gradual weakening or dismantling of fundamental questions, guarantees such as the separation of powers, or the independence of the judiciary, then we may describe this process as a constitutional coup d'etat. In this situation, law no longer plays only a protective role. Instead, it may become a tool that leads to results which are contrary to its purposes. And this leads to the key question: is formal legality alone enough to assess such actions? And ladies and gentlemen, moving further, it is necessary to clearly distinguish between two basic legal systems operating in Europe. On the one hand, we have the system of the Council of Europe, based on the European Convention on Human Rights, whose main goal is the protection of individual rights. This system is based on the principle of subsidiarity, which means that the primary responsibility for the protection of human rights lies with the state, while international mechanisms have a complementary role. On the other hand, of course, we have the law of the European Union, which has a different origin and function. It was shaped mainly as an instrument of economic integration and to ensure more uniform application of law. It operates on the basis of three principles: the principle of conferral, subsidiarity, and proportionality. This means that the Union acts only within the limits of competences conferred upon it, and at the same time, its actions should be necessary and appropriate to achieve its objectives. As a result, these two systems are based on different legal foundations and pursue different goals, which is important for assessing their role in the context of the problem that I'm analyzing. Ladies and gentlemen, moving to the question of the limits of international and European law, it is necessary to refer again to these two parallel systems. In the case of European Union law, the starting point is Article 5, of course, of the Treaty of European Union, which established the principle of conferral as well as the principle of subsidiarity and proportionality. According to this provision, the Union acts only within the limits of competences that were conferred on it by the member states. At the same time, however, in the case law of the Court of Justice of the European Union, for example, and especially in the case Commission against Poland concerning the disciplinary chamber of the Supreme Court, Article 19, paragraph 1 of the Treaty on the European Union has been used as a basis to assess national judicial reforms. At the same time, in the system of the European Convention on Human Rights, the principle of subsidiarity remains the fundamental one, which means that the state is the primary guarantor of the protection of individual rights. Despite this, the European Court of Human Rights, for example, and especially in the case of a Xerof law against Poland, assessed the composition of the Constitutional Tribunal in the context of the right to a court. This means that international review begins to extend into matters of constitutional and institutional nature. In this context, a key question arises about the limits of such review and whatever it still remains within the competences that were conferred on these systems. The question is fundamental for maintaining the balance between international law and the constitutional autonomy of the state. So, ladies and gentlemen, as we reach the key point of my presentation, it should be clearly stated that both European Union law and systems of the European Convention on Human Rights make it possible to identify violations of legal obligations by the state. And this is true. This function is an important element of modern legal protection, but it is not unlimited and must be exercised within specific rules and competences. In the case of the European Union law, particular importance is given to the interpretation of Article 19, paragraph 1 of the Treaty of the European Union, which has been used in the case law of the Court of Justice as a basis for setting requirements concerning the organization of national judicial systems. This interpretation has led to a significant extension of the scope of the provision in practice. On this basis, the Court of Justice of the European Union has assessed solutions adopted by member states, including Poland, especially in relation to the functioning of a disciplinary chamber of the Supreme Court. In practice, this leads to a situation, ladies and gentlemen, where the standard of effective judicial protection in the European Union becomes directly linked to the organization of national judicial system, even though this area traditionally belongs to the competence of the member states. This may be seen as a functional shift in the limits of competences. At the same time, the system of the European Convention of Human Rights, the European Court of Human Rights, as I underline it, in cases such as a Xeroflor against Poland, has assessed the composition of constitutional bodies in the context of the right to a court. In my opinion, this means that also in this system, international review begins to cover issue of a constitutional nature, and not only individual violations of human rights. As a result, both of these systems, despite their different legal foundations and different purposes in practice, enter the sphere of the constitutional structure of the state. And this is especially the point where fundamental systematic problem appears. The identification of violation by international bodies must remain within the limits of conferred competences and must respect principles such as subsidiarity and proportionality. However, what we can observe in a process which may be described as a functional extension of this mechanism and, in some cases, as a justification of the so-called coup d'etat, constitutional coup d'etat, where tools originally designed to protect individual rights or ensure the effectiveness of European Union law begin to affect constitutional structures. In this context, we can see a shift in the boundary between legal review and interference in the organization of public authority. This boundary is fundamental because it defines the scope within which the state preserve its constitutional autonomy and its ability to shape its own system. So, if this boundary is crossed, international begins to influence not only the legality of state actions, but also the structure of the constitutional order itself. And this leads to the key question about the limits of such interference and about the relationship between international law and state sovereignty. So, ladies and gentlemen, I think that I skip one slide, so that should be now. I will remain this slide for a moment, and in one moment I will go to the next one. So my considerations lead to a fundamental conclusion concerning the limits of international and European law. There is no doubt that these systems can identify violations of obligations by the state and perform an important controlling function. However, this function, as I said, is not unlimited and cannot be treated as a basis for interference in every sphere of state activity. It must remain in line with the principle of confer, subsidiarity, proportionality, what I described, which define the limits of both European law and more broadly international mechanism. In particular, it should be clearly stated that international and European law should not be used as a tool to shape the constitutional system of the state or to interfere with the basic institutional structures. At the same time, as mentioned earlier, the interpretation of Article 19 of the Treaty of the European Union in practice leads to an assessment of national judicial systems, and similar tendencies can be observed in the system of the European Convention on Human Rights, where review begins to cover issues related to constitutional bodies. So, ladies and gentlemen, crossing this boundary has serious consequences because it leads to the weakening of the constitutional autonomy to the state of the state and to questioning the principle of sovereignty, which remains one of the foundations of the modern international order. Therefore, it should be accepted that the identification of violations by international bodies is acceptable only within the limits of conferred competence and cannot lead to replacing domestic constitutional mechanism of functionally taking over the role. As a result, in situation where actions are systematic in nature and carried out within formal legal structures, primary responsibility should remain within domestic law. This also applies to the possible individual responsibility of public officials, which in the current model of international law does not have a direct and developed mechanism of enforcement. It is at the level of the state that real responsibility for the actions of constitutional organs is determined, including the actions of individual public officials. So, in my opinion, and it is precisely this boundary that defines or should define one of the fundamental features of contemporary international European law, the boundary between legitimate control and unacceptable inference in the sphere of the state sovereignty. So, ladies and gentlemen, and this accent, I would like to end my presentation, and thank you very much.